online. So if anyone doesn't want their image, on LinkedIn or anything, I would advise you just to pop your cameras off. I'm expecting it to be a very busy call as well today, so if I can just ask you all to stay on mute. But if you have a question at any point of the question and answer sessions, just feel free to put your camera and mic on to ask your question. That's absolutely fine. After the session, there'll be a lot of information today, but after the sorry, can everyone just pop themselves on mute? Thank you. There'll be a lot of information we'll go through today, but don't worry, we'll send out the slide deck at the end, so you'll have that to go through. And all the information that we refer to, we've put hyperlinks in the slides, so you'll be able to click on the link in the slides, and it will take you to the relevant information. Sorry, my slides have just disappeared. Just going to get them back up. Just checking, could someone give me a thumbs up that they've came up? They've unfroze for me now. Perfect. Thank you. So Kevin and I will be presenting this morning, and what we've done is we've gone through the Employment Rights Bill and we've tried to pick out the key areas that we think either members will have, the most questions about, or that might impact our members the most. But the bill itself is quite expansive, so we'll go through in a lot of detail, the key areas that we think you'll have the most questions on. So I'll give us a general introduction to the background of the bill and where the bill is at present and when we can start to expect seeing these changes come into force. Kevin's then going to take you through a look at protection against insecure hours of work. So you've probably heard a lot of discussion in the media about the banning of 0-hour contracts. So that's going to factor into that section. I'm then going to take us through a big one, which will be making unfair dismissal a day one right. That's one we've already had quite a lot of questions on, so we'll spend a bit of time going through that, and hopefully by the end of that, you'll feel a bit more relaxed that we've got a lot of time to get our processes in place for that. Kevin's going to take us through the reforms for fire and rehire and collective redundancy, and then I'm going to finish up my last section on collective labour law reforms. Kevin's just got a quick update on what the proposals are for the flexible working regime. And at the end, we'll try to leave time just to have a discussion and have a bit of a Q&A about what we've gone through in the session. Because it is a busy call as well today, we will be monitoring the chat function. So up the top of your screen, there should be a little speech bubble with a chat box. So if as we're going through you have any questions, feel free to type them in there. Some of them we can get back to you in writing and everyone will be able to see the answer. But at the end of each session, we'll take a few questions as well. So an introduction to the Employment Rights Bill. You'll likely have seen lots of information about it in your various employment law updates in your email inbox, on LinkedIn and the news. And it was delivered on the 10th of October. That's when we got sight of the first draft of the Employment Rights Bill. And that came following Labour's pledge during the election process that they would give this bill within 100 days. And I think we got it in 99, so with a day to spare. So the Employment Rights Bill itself, it covers a wide-ranging area, but if you actually go on and look at the bill, which is hyperlinked in the slide, a lot of it is just headline proposals. And what you'll see is that the fine detail of how it's actually going to work in practice is going to be given in later regulations. So we have an idea of what the proposals are, but what you'll probably notice as we go through is that the fine detail is to be in later regulations. And at present, the bill is being published and it's just passed its second reading in the House of Commons and heading to committee stage. So it's fairly early on in the legislative process. And as it goes through the legislative process, we can expect some aspects of the bill to change, and we'll highlight different elements of the bill that are subject to consultation still and might be privy to change as we go through. So as well as the Employment Rights Bill, which is written in your usual legislative language, the government also published a policy document the same day. We've hyperlinked it again so you can click and have a read. And that's their policy document called Next Steps to Make Work Pay. And you'll notice that this is written in much more user-friendly language, and it tries to explain the key areas of the employment bill in plain English. So I would recommend having a read at that policy document. It's a good starting point if you've not looked into the bill much. And if you have a look at that document, there are some key themes that we can see running through the bill. We'll cover these off today, but the general themes that I've picked out are, a general push towards extending employment rights. So we see that in things like extending unfair dismissal to be a day one right of employment, extending certain family leaves where you normally have a minimum service requirement, like parental leave, paternity leave. So making these rights effective from day one of employment. We also see a push towards increasing the right to work flexibly. They have a push in making this in a fair way. So I think the kind of language they use is one-side flexibility. So, a lot of discussion on banning zero-hour contracts and these types of working practices and making flexible working the default position. We also see a key theme in strengthening the role of trade unions, which I'll speak about towards the end of the session, but a lot of repealing recent legislation that's come into force on trade unions, as well as introducing new rights in respect of collective labour law. And we also see a key theme in reforming the statutory sick pay scheme. And all of this is detailed in that policy document, Next Steps to Make Work Pay. So some aspects of the bill will be subject to further consultation, which I think is a good thing because it shows that the government, there are still areas where they're willing to consult further, get more information from stakeholders, employers, legal professionals who use this area of law. So some aspects that they're still open to consultation on are 0 hours contracts, collective redundancy and fire and rehire provisions, some trade union aspects and SSP. So again, I've linked where employers can actually participate in the consultations on the slide. And if you go on and look at each of the consultations, they're asking questions about specific aspects of each of these things. So there's still an opportunity for you to give a bit of industry influence and view in the consultations. And they all close early November. So it's the 2nd December for all of them listed above, apart from SSP, which is the 4th of December. So that's just a quick run through of the background to the bill itself. We're now going to look at the more specific sections. So Kevin's going to kick us off with the protection against insecure hours of work.
Okay, folks, hopefully you can all hear me. Amy, if you can go on mute as well, ideal, thank you very much. So, protection against insecure hours of work. This basically covers, shall we say, 3 major aspects. And here are the, shall we say, the government's underlying ethos behind this. As Amy mentioned, there's a hyperlink to the Next Steps that makes work pay document. It's written in that much more plain English type of format. And one of the main aspects is the government is trying to end what's known as one-sided flexibility and kickstart economic growth. When I say one-sided flexibility, in that the employees are expected to change their lives and change their circumstances to fit what the employer needs. And perhaps some people in government see that as being perhaps too one-sided or a disproportionate amount of power on one side. Therefore, they want to perhaps even up the balance a little bit. What Angela Rayner says, they're wanting to put in place a baseline level of security and flexibility for all jobs within Britain. And the bill attempts to stem what's known as a rising tide of insecurity that has accompanied low growth, low productivity and low pay. And you'll hear us talk later on about the low productivity aspects as well. And many legal commentators and academics have commented on this particular aspect as well. It's to try and drive growth, drive productivity, and increase pay as well. However, as those legal commentators and academics have said as well, these bills provisions are daunting in their detail, length, and complexity as well. And again, as Amy mentioned earlier on, there are consultations out to get some further detail on these as well. As I mentioned, three different sections, sorry. Right to guaranteed hours, reasonable notice of shift changes, and payments for any shifts that are cancelled, moved, or curtailed. So, the right to guaranteed hours. A lot of the information on this will come out in regulations further on down the line, and what a regulation is a common parliamentary tactic. The bill itself will eventually become what's known as primary legislation. It's the main statute. You may have heard of things like the Equality Act or the Employment Rights Act. Those are bits of primary legislation. However, they have to go through quite an involved legislative process with many, many votes, many, many readings, whereas the detail of many aspects of law is brought out in what's known as regulations, which are known as secondary legislation. And these are enacted in a much more straightforward way. So when Amy and I are perhaps dodging bullets a little bit to say we don't know what the reasons, what's happening here, it's because we don't know. It's because a lot of the information that's going to come out on these things will come out later on in regulations. So the right to guaranteed hours is only for what's known as qualifying workers, which is going to be, shall we say, somebody whose working pattern over a specified reference period, probably going to be 12 weeks, reaches a specified threshold. Now that threshold itself is going to be something which is going to be argued about. Is it going to be 2 hours a week, or 16 hours a week, or 24 hours a month, or something along those lines? And if somebody is deemed via these regulations to be on 0 hours or in low hours, but actually works more than these hours over that reference period, okay, therefore they have the right to move to a guaranteed hours contract, or specifically they have the right to be offered one by the employer, and then they can choose to accept it or not. Now, guaranteed hours contract, that is something which, to quote, reflects the hours they regularly work over the 12-week reference period. If more hours become more regular over time, subsequent reference review periods may have to be looked at, which will thereafter allow the employee to get perhaps a further guaranteed hours contract as well. So this will perhaps involve the employers being much more aware of the variability in the hours that they offer to employees, and to perhaps try and even out a bit. Now, I realise that not all companies and industries, or even sectors of industry, have a very stable amount of work coming in. It can fluctuate by a whole number of different metrics. Client demand, number one, availability of products, availability of finance, availability of supplies, etc., etc. All of these things can impact upon the availability of hours. So certainly record keeping will be something which is much more prevalent going forward. Reasonable notice of shift change. Now, a change itself can be a different time, a new shift entirely, a cancellation of a shift, and importantly, it's not just for 0 hours workers as well. And obviously 0 hours workers are people who have invariably had much more flexible and unpredictable types of jobs and rotas. So it will also extend to workers who have some guaranteed work, but whose contract does not specify the days or times when they must work. Now, what the employers will eventually have to give to employees is a reasonable amount of notice for a shift change. And again, what reasonable will be on the circumstances of the case. So what's reasonable for perhaps a nurse will not be the same for a cleaner, will not be the same for a machine operator, will not be the same for an accountant or a locum doctor or whatever. Again, detail will come in the future regulations as we go on. And as was hinted at earlier on, consultations are open. Thereafter, regulations will get brought in force. That will be many months down the line. The actual impact of this in the real world, when these regulations and the primary legislation kicks in, might not be until 2026. And that's during that time we'll have further detail, and Scottish Engineering will be able to advise you on preparatory steps to put in place prior to the imposition of things like reasonable notice for shift change, and certainly the unfair dismissal matters that Amy will touch on later on. Now, payment for cancelled, moved or curtailed shifts. That pretty much does what it says on the tin. So if the employer cancels or moves a qualifying shift at short notice, both of these to be TBC, okay, in specified circumstances or not, then they may have to make a specified amount of payment to the employee. Again, dodging bullets here, don't know what the specified circumstances will be, don't know what the short notice will be, and we certainly don't know what a qualifying shift will be. But again, this is something that is going to be coming over the horizon, and as more detail is filled in by the government, then we will update you as time goes on. Okay, I just hand it over to Amy to continue on with unfair dismissal.
Thanks, Kevin. So another big one, and one that I've certainly had a lot of questions on already. So we'll go through this in as much detail as we have at the moment. Just to start off with I think the key point that we do know from the Make Work Pay policy document that this is going to take effect no sooner than autumn 2026. So what that means is that employers won't be bound by these rules until that point. So it does give us a lot of time to change our policies and procedures and make sure that managers and any HR teams are fully on board with the new rules. And we'll speak through some practical steps that I think will be important when this comes in place as part of today's session as well. So if you look at the bill, what it proposes to do is remove the 2-year qualifying period, which is currently required to make a claim of unfair dismissal to the Employment Tribunal. So this is obviously quite a big change because at present, if you have an employee who has under 2 years service, there is a much more relaxed rules around the fairness of that dismissal because they don't have the rights to make that claim to the Employment Tribunal. So that can often involve a shorter process or no process to do that dismissal, but that's going to be different now with the new change. So if you look at the bill, the language it uses is an initial period of employment. So you've probably heard a lot in the media and in your legal updates that there's going to be an exception, meaning that there's going to be a statutory probationary period. And in that time, there's going to be more relaxed rules. So although they'll be able to claim unfair dismissal from day one employment, the government does recognise that there does need to be a period where they can assess the suitability of that candidate and that employee. So they've made provision for there to be this initial period of employment whereby you can make that assessment, and it's thought that there's going to be more relaxed rules around dismissing that employee during that initial period of employment. So right now what's proposed is that this period with the more relaxed rules is going to be 9 months. But again, the bill is still going through the legislative process. So that 9 months might change as a result of that, but that's the number we have at the moment. So dismissals that you make, even during that statutory probationary period of 9 months, they still need to be for one of the potentially fair reasons for dismissal. So while at present, there's no way at present a dismissal for someone with under 2 years service, there's nowhere for them to challenge if their dismissal isn't for one of those potentially fair reasons. But going forward from autumn 2026, you'll need to be able to demonstrate that all dismissals you make, even during that statutory probationary period, are for one of the potentially fair reasons. So there will be an exception here that's been indicated in this first draft of the bill, being redundancy dismissals. So any dismissals you make for reason of redundancy, even from day one of employment, it will be expected that you follow a full fair redundancy process for that individual. So the other fair reasons would be conduct, capability, or some other substantial reason. So all dismissals will need to be for one of those reasons. And again, we don't have the fine detail of exactly what's going to be required process-wise in that initial 9-month period. But if you look at a lot of the academic commentary, what they say is that fairness will be assessed with a lighter touch. So we'll await the details for this again in future regulations. But I did have a look to try and see if we've been given any indication of what sort of process you would need to do with someone who is in that probationary 9 months, to show that the dismissal was fair. So in the Make Work Pay document, they did give a slight example. Again, it's not much, but it's what we have at present. And it says that an idea of what the shortened fair dismissal process during that initial 9-month probationary period could be. And just to quote it directly, as a starting point, the government is inclined to suggest it should consist of holding a meeting with the employee to explain the concerns about their performance, at which the employee could choose to be accompanied by a trade union representative or a colleague. So again, that's not a lot of information at present, and it does say that they're going to, think about how the ACAS Code of Practice and Disciplinary and Grievances interacts with this shorter process that will be required. But I think at the very least, this indicates that if you're making a dismissal for someone in that 9-month probationary period, you need to be giving them a chance to improve, explaining what the issue is. So even in this probationary period, some process is going to be required, and we'll keep members updated on exactly what that process is going to look like. So just having a think about what impact unfair dismissal being a day one right will have on your employment practices. So I think a really big one is that we're going to see more focus on recruitment processes, because now that an employee can claim unfair dismissal as a day one right, and it's going to be harder to make these dismissals and more process involved. I think employers are really going to want to make sure that when they're bringing someone on board, that they are a good fit for the business, and that they've got the capabilities and skills they need for the role. Another one will just be making sure that the performance management is happening during that probationary period, because now you only have this 9-month period where you can do a shorter process or a less detailed process, but you need to be able to demonstrate that there are genuine performance concerns. So you'll need to be really on top of, managing and monitoring people's suitability during the probationary period so that you can show that dismissal is fair. Again, we'll likely need to look at our employment contracts, because they'll need to clearly state that the employment is subject to that statutory probationary period. And I think as well, for conduct matters at present, if someone has under 2 years service, it might be that they go through a much more relaxed disciplinary procedure for conduct because they can't challenge the fairness of the dismissal. But now, in the future, when unfair dismissal is a day one right, it might be taking a view on, for all conduct matters and instances of misconduct, ensuring that you're following your procedures for all employees to make sure that the dismissal is fair. And another huge one is just going to be making sure that you have adequate records, whether that record's relating to performance or conduct concerns. And even if those conversations are informal, you want to make sure that you have a documentary paper trail which shows the issues in employment. So if you're making a dismissal, even in that 9-month probationary period, you can show that you've given them chances to improve, had conversations, had meetings where you raised the issue. So, ensuring you've got those records is going to be really important. And I think performance management in particular can be a difficult one for managers, and it's not something every organisation's always good at necessarily. So now that we know this isn't coming into force any sooner than August 2026, it might be a good time to think if there's any specific teams or training that you think would be useful for managers, just to make sure that they're comfortable with performance management and they know the process required. We've got kind of good year and a half to think about what training our teams might need to make sure they're up to speed for this coming into force. Thank you very much. I'll just pass back to Kevin, who's going to take us through the fire and rehire and collective redundancy reform changes.
Okay, right. Thanks very much, Amy. Right, fire and rehire and collective redundancy. So they are both types of dismissal. Obviously, the word fire is synonymous with dismissal, and collective redundancy word itself, is a type of dismissal in its own right. But two of them are governed by certain laws just now, and those laws and rules are going to be changing over the next couple of years. So everyone will remember these headlines from a couple of years ago when P&O did a mass sacking of, I think, some 800 staff by, I think, a Teams or a Zoom call with their HR director. Basically says, you are now dismissed, you get paid in lieu of notice and any other statutory payments, goodbye. Now, there was rightly outrage in the press from trade unions and even within the then Conservative government as well about the rather heartless and unlawful way that this had taken place. So, what happens in that sort of circumstance? If you take a step back and think about it legally, fire and rehire is where the employer imposes terms and conditions changes onto an employee. As anyone who's listened to me over the phone talking about employment law, a contract is a bilateral legal agreement that cannot be unilaterally changed by one party. If one party wants to change it, what you do is you speak to the other party, propose the change and see if they accept it. Usually if it's a beneficial change like a pay rise, they'll accept it. If it's a detrimental change like a pay cut or something else which impacts upon them detrimentally, they will refuse to accept that change. If you were to impose that change on them, that's a unilateral breach of contract, which might leave you open to what's known as a constructive unfair dismissal claim, which is a whole other story in its own right. So if a company wants to impose a change like that, what it usually did is it terminates the current contract with notice or a payment in lieu of notice, and then seeks to rehire the employee on the new contract with the new terms and conditions. Hence the term fire and rehire, or to use its legalistic name, dismissal and re-engagement. So with my employment solicitor's hat off, what that basically involves is the more powerful party, the employer, exercising its economic power to basically impose downgraded terms and conditions on the weaker party, the employee. So even if they were to consent, it's all dubious legitimacy when the alternative is dismissal. However, currently, fire and rehire, dismissal and re-engagement is lawful if the employer has reasonable grounds. If, when the employer balances the needs of the company versus the needs of the employee, and there is a benefit to the employer on a reasonable basis, then that should be enough to get it through under the current rules. However, what's going to happen under the new regime in a couple of years' time is it's going to be automatically unfair to dismiss an employee if the principal reason for dismissal is that either the employee refused to agree to a variation of contract sought by the employer, or was dismissed to enable the employer to recruit another person or rehire that employee but under new terms but with substantially the same duties. So basically, fire and rehire that same employee is going to be automatically unfair. Fire and rehire somebody else, which happened in P&O, that's also going to be automatically unfair. However, there is going to be an exception to that if the employer is having to restructure to remain financially viable. Okay, and the various legal commentators and academics that I've been reading would say that this is a very high legal hurdle. Okay, and financial difficulties is mentioned, the going into administration, things like that, something which is going to be of fundamental danger to the organisation on an ongoing basis. So basically, the terms and conditions change with the employees has to be a last resort, okay, last chance saloon. And again, many of the lawyers and legal commentators that I'm reading are saying they don't want to be the first to have a test case where an employer is having to argue that this, the last chance that they had was an imposed terms and conditions change via fire and rehire process. Okay, they don't want to be the test case on that as well. But what they are saying, and what I would concur with, is there might in future be much more prevalence of what's known as contractual variation clauses. Okay, and these actually allow the contract to be changed by the employer without necessarily the employee's agreement, because the power to contractually change the contract itself is already baked into the contract. So a contractual term might be, the contractual variation term might be something along the lines of, company reserves the right to change X, Y, and Z terms of the contract as per the needs of the business from time to time. Now, that's a very generally worded one. You might see much more specifically worded ones on pay or hours or holidays and things like that going forward. But that's the general thrust of where people think that we're going, is rather than having the ability to terminate and rehire, you'll just have the ability within the contract itself to make variations. And certainly Scottish Engineering will assist you on that as well. Moving on to the next area now as well. As I mentioned earlier on, redundancy is a type of dismissal. Amy mentioned beforehand that you've got things like conduct dismissal, capability dismissals, some other substantial reason dismissals. Redundancy is a type of dismissal. And generally, just now, if you want to make a employee redundant or less than 20 redundant, there's a fairly formalised process you have to go through of consultation, selection of people at risk, and if it's within a pool of people, you have to go through some sort of scoring criteria process. It's involved, but it's relatively straightforward. Things become slightly more structured if you have more people being dismissed. And as you can see from the first two bullet points there, it is 30 days collective consultation if it's 20 or more within 90 days, or it's 45 days collective consultation if it's 100 or more within one establishment. Okay, and what collective consultation means is you've got to send certain documentation, what's known as a Section 188 letter, which you give to the trade union or your employee representatives. You also got to put in what's known as a HR1 form to the insolvency service, which is part of the government, which again is not impossible, it's not difficult to do, but it's just slightly labour intensive, and it means you've got to structure your thoughts early on in the process about what's actually happening. Plus, collective consultation, as it says on the tin, you've got to collectively consult with the representatives as well as with the employees themselves. Now, that adds in further administration, further management time to a process that's possibly already quite involved. What the new laws are going to do is they're going to remove the words "at one establishment." Now, that might not seem a major issue just now, but it is actually quite a major change, because the terms "at one establishment" has actually been litigated to the higher courts many, many times as well. And what an establishment is meant to be, it's almost like a separate location within an organisation. So it has perhaps its own management structure, a different geographical location, minimal, if any, interchangeability between staff. So what that also means for bigger employers, if they were doing a redundancy and it could be found that their different branches were separate establishments, they perhaps didn't have to go through the collective consultation regime if there were fewer than 20 at each individual establishment. They didn't have to aggregate them all together. Now, if the words "at one establishment" are expressly removed from the statute, then, as I've said there, bigger employers beware. Because you've got, for example, 10 employees in London, 7 in Cardiff. At that point, you're 17 underneath the collective consultation, but then you're making another 5 people redundant in Edinburgh. The argument is the collective consultation regime triggered because you're now at 22, albeit at 3 separate geographical locations, but now not separate legal establishments. So it may well be that there's a lot of autonomy, for example, with regional directors who don't talk to other regional directors, and they're quite happily making their 10, their 15, their 12 people redundant, not realising that other regional directors might be collectively, when you put them all together, going over 20 or, heaven forbid, going over 100. So you may have to argue that they're all genuinely separate redundancy exercises, okay, and not driven by what some commentators are calling a common underlying business reason. So again, one to watch. Again, more information will come on that as time goes on. Now, currently, if an employer gets it wrong with collective consultation regime, then they may have to pay up to 90 days pay of a protective award to each individual employee. And as you can see, that if it's a very large scale of 100, 200, or even some 400 or 500 members of staff being made redundant, that can be very, very expensive for an errant employer. Now, the protective award is punitive. It's meant to be a punishment. Okay, it's nothing to do with the financial losses that the employees have suffered. It may well be that the employees are made redundant quite happily and go off and get a better paid job and pocket the redundancy pay. However, if there has been a breach of the collective consultation regime, they're still entitled potentially to a protective award as well. Now, issue with protective award was highlighted by the P&O Furora a couple of years ago. They basically made a financial calculation that was cheaper to pay all of the redundancy monies, notice monies, and the protective awards to the employees, and potentially a little bit of on top as well, rather than keeping them on under what was then their terms and conditions. So for deep-pocketed employers who are quite happy to pay the protective award, they can do it. It becomes basically a financial calculation of how much do they pay in protective award and the other statutory payments versus how much are they going to save by making these people redundant without going through the process. Now, there are calls potentially to make the protective award more punitive, to go above 90 days, 180 days, perhaps even more. That will certainly be more costly, but again, depending on how deep the pockets are of these bad employers, that might not be enough. Again, some legal commentators are calling for criminal sanctions against the directors who authorise what's known as or suggested as a flagrant or aggravated breach. Okay, now such sanctions are hopefully not going to be aimed at a well-intentioned company who's planning to go through the collective consultation, but for whatever reason makes a technical breach of the collective consultation regime. So moving on to the next slide. Collective labour law. I think that should be back to Amy now.
Thanks, Kevin. So another key theme, as I mentioned earlier, is a reform of collective labour laws, and that takes a couple of forms, in repealing existing legislation and also introducing some new legal rights. So we'll discuss both. So if you look on the Make Work Pay policy document, what they say their intention is with the reform of collective labour law is that they intend to strengthen the legislative framework which underpins trade union laws as part of their pledge to strengthen workers' rights. So it goes back to this idea of strengthening employee rights in the workplace. So the first two pieces of legislation which they've said in the employment bill will be repealed are the Strikes Minimum Service Levels Act and the Trade Unions Act 2016. So the Strikes Minimum Service Levels Act, that was actually only brought into force last year. So you maybe remember us speaking about it in a previous legal update. But this was the piece of legislation which applied to certain what they call critical industries. So things like education, emergency services, healthcare, and it allowed government ministers to set minimum service levels for those critical industries. And it meant that if there was any strike action, in essence, workers who would have been in favour and would normally have been striking could be mandated to remain in post and work during the strike to keep that minimum service level in action. So as you can imagine, this almost in a way lessens the impact of the strike. So Labour, the Labour government have now legislated in the employment bill that they propose to repeal this act. Another piece of legislation, a bit older this time, is the Trade Union Act, and they've said that this will be repealed as well. And I think one of the key features that a lot of legal commentators are currently writing about is that it's this piece of legislation which sets out the turnout threshold for a strike ballot. So right now, 50% of the eligible members of the trade union, they need to vote in that strike ballot for the strike to be effective. And by repealing the Trade Union Act, it would remove this turnout threshold. So at present, there's a lot of question marks about, will this make it easier for strikes to take place? We don't have a lot of information on it at present, because while we know that Labour plan to repeal these two pieces of legislation, we don't know what, if anything, they'll be replaced by. So we don't know if they're going to be replaced by something which reduces the turnout threshold, or if it will be removed entirely so there's no threshold, which I don't know how that would work. So we just don't have that level of detail at the moment. But what we do know is that they are going to be repealed if the bill is successful. So as I say, in addition to existing Labour laws being repealed, there's also some proposals of new legal rights in the bill. The first is that there'll be a right to a statement of trade union rights. So what that means is that as an employer, all of your employees should receive a statement which sets out their trade union rights. So that's one worth thinking about. Is this going to be something that we give along with our Section 1 statement or the employment contract? Is it going to be part of that onboarding process to make sure that they receive that? And no doubt this is something that as we get closer to the time and we get more information, we'll be able to assist members with. But that's going to be a legal right and something that employers will need to comply with. The next one, this has been subject to a lot of legal commentary, and that's because it's going to actually be a right for unions to enter workplaces. So it's a right of access for them to come in and facilitate collective bargaining. So what that means is that they're able to come in and access the employer's workplace for purposes of collective bargaining. So things like meeting employees or potential members, representing, and also to recruit and organise members in the workplace. It does say in the guidance, the policy guidance, that there'll be clear rules of the boundaries of this and how this will work, but we don't know what those clear rules are yet, so that'll be interesting to see. But generally, this has been pretty well received by unions, and it'll be interesting to see how they plan to govern this. And from what I can gather, if an employer doesn't allow the union rights of access, there will be consequences or penalties for not allowing the right of access. So it'll be interesting to see, what those penalties or consequences are, and we'll keep you updated on that point. And then another interesting one is that they've said there'll be a new legal right in terms of setting up bargaining institutions such as sectoral agreements in adult social care. And reading a bit more into this, they've acknowledged that in adult social care, there's low trade union membership uptake. So it's essentially bringing this into the government's hand and making a centralised bargaining institution for that whole sector. So definitely an interesting concept to see how that works and how successful it is. It's the idea of this almost negotiating body set up by the government. There's actually been a fact sheet released on that on the gov.uk website. If any of our social care members on the call are interested in that, I can pass that on. Thanks very much.
Okay, Amy, just there's been a couple of questions in the chat.
What minute I just open that?
Yeah, just open that. They're specifically on this. They seem to cover the same area. Do these rules apply when there's not a trade union already recognised?
Would the trade union, so would this be the right of access? So right now, the general wording in the bill is just that, again, it's that point of we don't have the finer detail in the regulations, but certainly in the bill just now, from what I've read, there's no sort of exception that it needs to be a recognised. What we know is that there'll just be a general right of access to enter the employer's workforce. And we do see that one of the reasons in the policy document is to recruit. So it'll be interesting to see when we get more detail of how it's going to work in practice. Other question, is this the Fair Work Agency? I think this is something different. This is a separate thing. Lauren, and if it's any use, I can get in touch with you after to send you the fact sheet for the adult social care negotiating body, but something different. And I see we've actually had 3 questions about whether the trade union has the right of access into to a company that doesn't recognise a union. So given there's a bit of interest in that, I'll do my digging and my reading and the limited information we have and see what we can pull together for you and send out along with the recording. Because it's definitely one of the more interesting ones, for sure. So I'll follow up on that. Thanks very much. If we have no other questions in that section, it's over to Kevin for flexible working.
Okay, right, flexible working. Right, many people out there think that employees have the right to flexible working. They don't actually have the right to flexible working. What they have is the right to request flexible working. And what has happened over the years is that right itself, in itself, has become slightly more flexible. People from a few years back might remember that initially flexible working requests had to be for when you had a child of a certain age or a disabled child of a certain age. It was originally you could only make one request during a 12-month period. Those sort of family-orientated requirements of having the children of certain ages, they're now gone, and you're now able to make 2 requests within a 12-month period. Now, going through the process, an employer should meet with the employee, discuss the matter, and then find out whether it can be accommodated or not. If the company wants to refuse it, either in whole or in part, currently it has to be a refusal on one of these statutory grounds. And there are 8 of them: burden of additional cost, detrimental impact on quality, planned structural changes, etc., etc., etc. Now, currently, you really only just have to say, we are refusing your flexible working request because of the burden of additional costs, full stop. You have the right of appeal, yours sincerely. Now, what the change will be is that the company has to thereafter justify what the refusal is. They have to say why the refusal is reasonable. Now, practically every one of the lawyers and legal commentators' notes that I've read have said that this is a very modest change. The reason being is that the vast majority of employers already do this. Because certainly anyone who comes and takes advice from me about refusing a flexible working request, I always say, just use one of the 8 statutory grounds, but use it as a headline. Then go into a bit of a narrative to say why it's going to have a detrimental impact on quality. Tell them why it's going to have a detrimental impact on performance, rather than just using those bald statements. Not least, you're probably going to get better buy-in from the employee if he or she realises that what they're asking for is genuinely not going to work with the employer, as opposed to just getting a one-liner back. But what it also does currently is that there is more to a flexible working request in the background, because if somebody has a flexible working request denied, then there is a possibility, and I use no more than that, just the possibility that they may try and raise an indirect discrimination claim. So say, for example, somebody, a woman, wants to work part-time hours or have flexi time, but the company has a specific rule that says no, everyone has to work full-time, Monday to Friday, 9 till 5, no exceptions. Now, if that workplace rule on the face of it affects everybody themselves, but actually when you scratch the surface, disproportionately affects one group of people, for example, women with young children, and since most people know that the majority of the child caring obligations fall on women, then that's indirectly affecting her detrimentally, which could be seen as indirect sex discrimination. Or with the same company who has the same inflexible Monday to Friday 9 till 5, somebody with an underlying health condition says, can I work flexibly or get every third Thursday off for a couple of hours so I can get chemotherapy treatment? And the company says no. Right. Obviously, there's potential for indirect disability discrimination there, because somebody has cancer, they're going to be deemed as disabled, and the lack of flexibility could indirectly impact upon them detrimentally. Therefore, it is a indirect discrimination claim regarding disability. Now, those are fairly stark examples, but you can see how if a company doesn't have its justification in line for the reasons that it gives, then that would leave it open to an indirect discrimination claim. Now, that's under the current situation. it's going to be the same in the new flexible working regime, where you merely have to justify what your reasons are. I've always been advising companies to justify why they're doing things anyway, because if a company has what's known as objective justification for the reasons that it has, for the actions that it takes, then usually that's enough. An employment tribunal will not overrule what a company does. You've seen, depending on what newspapers you read, people will now be able to demand 4-day working or long weekends or flexible working. That's not the case. So long as the company has its ducks in a row about its justification about why a flexible working request will not work under one of those 8 reasons, then you can validly refuse it. So if somebody, for example, wants to start at 10 o'clock in the morning, when usually they start at 7, and you can say, no, the vast majority of our customer interactions are between 8 and 10, then no, you can validly return that. Sorry, you can validly refuse that because there's an insufficiency of work during the periods that the employee proposes to work, or it's going to have a detrimental impact on quality, or it's going to have a detrimental effect on ability to meet customer demand, etc., etc. And here is why. This is what your reasonable justification is as well. So moving on to overall summary of what the Employment Rights Bill is about. It's tackling bad work, trying to get rid of bad employers, or at least change their behaviours to make them more productive and less invasive onto their staff. The government is trying to reverse the productivity slowdown. If you read many industrial journals, you can see that the UK has very poor productivity. The amount of work gotten out of each individual employee is less than their major industrial competitors. To take one example of what's coming through in the Employment Rights Bill, currently, depending on your point of view, an employer doesn't really have to performance manage an employee that much during their first 2 years of employment, because if the person doesn't work out, you can get rid of them relatively easily because they've got no unfair dismissal rights for those first 2 years. Now, you've got 9 months, perhaps maximum, and you've got to performance management during that time to get them up to speed quicker. So training, regular appraisals, make sure you document things. If there are problems, try and deal with them early doors. And all of these things are hopefully going to make the employees much more productive. And what they're also trying to do is incentivize workers to work. There are many people out there, for whatever reasons, who are not within the workplace. Perhaps the companies that they want to work for have too rigid working patterns. They're not flexible enough. So hopefully, if flexibility can become more entrenched within the organisations, then that might bring people out of unemployment from the dole into the workplace, and it might make people less likely to leave the workplace if they realise that they can get a bit more flexibility as well. Trying to get away from not a race to the bottom on standards as well. We're never going to compete with the Chinas or whatever, who have hugely labour pools, vast labour pools at very low wages. We're never going to be able to compete with that, and I don't think we should either. We're wanting higher wages, but higher skilled, value added industries and companies, most certainly. Unsurprisingly, trade unions are largely supportive of these rules, albeit there have been some quite pointed criticisms on individual parts of the Employment Rights Bill, saying it's not went far enough. I'll leave you and your tea and toast to work that out yourselves. However, some newspapers are saying that this is going to add an extra £5 billion in costs per annum to UK businesses, with potentially a disproportionate amount of those costs falling on smaller businesses. We will wait and see on that as well. But final bullet point, as it says on the tin, this is the biggest change to employment law in a generation, most certainly. And on that note, with 5 minutes to spare, any further questions for Amy and I? Heard somebody coming on yet?
While everyone's thinking, just had a chance to quickly look further and just confirm the position on the trade union rights to access. So from everything that's out there just now, it's very much drafted that the wording is just listed trade unions. So, you know, it can't just be a kind of dodgy setup union. It needs to be a listed trade union, has a right to request access to a right of access to employers' premises. But what it is saying is that there is going to be some sort of formal request procedure, and you have to have a reason to deny it. So the default is that they've got the right. But again, it says this will be given in secondary legislation. So we don't know what that formal process and how it's going to work will look. But that's what we know at the minute. So hopefully that clarifies that one a bit.
Okay, right. If we have no further questions, then I'm going to stop the presentation just now. But if you're anything like me, whenever I log off of a webinar, 5 minutes later I've got a question I should have asked beforehand, email us, phone through or email us, that's not a problem at all. On that note, going, gone. See you later, folks.
Bye, everyone. Thank you.
Bye-bye.
Thank you. Bye-bye.
Thank you. Bye.
Thank you.
Thank you.
Thank you.